where that came from, but I do know that it turns up in a lot of plans, so perhaps Commissioner McMahon may have some idea.
I don't.
No. The other matter for me with regard to the water supply is that I think to require any subdivision in the future urban zone to actually connect to a reticulated water supply is overly onerous, given that currently it's a rural zone. The level of subdivision that they can undertake is severely limited. They do have a whole heap of other constraints on them, and that until such time as they're actually rezoned for their urban purpose, they should be allowed to retain an on-site water supply. They can only do a 20 hectare subdivision as a controlled activity. So that's pretty much all the comments that I have with regard to that matter. With regard to sub R4, which is the rural production zone, I appreciate Ms. Lawrenson's rereading. She addressed the issue, the predominant issue that I had with the contradiction between what was included in the law and what was included in the performance standards, particularly with regard to minimum lot size. I've suggested some rewording just because I found it a little bit confusing how she reworded it. So I thought perhaps that might provide a slightly clearer, that was my understanding of what she'd written in slightly less words. And I've also noted that I had to make a change to my suggestion for Eco S6 based on what came out of this application. That's the one to do with the additional allotment for Esplanade. Getting on to the Esplanade reserves and strips, I believe that there's actually general recognition of the value of water bodies. So it's not that that's the issue, but more how you provide for those values. As I noted in my evidence, prior to the operative district plan, there were Esplanade strips and reserves that were being created that were landlocked and inaccessible. And so the operative district plan focused on trying to get Esplanade strips by identifying priority water bodies, which enabled them to be created more quickly. This had a couple of consequences in terms of the compensation that was required for Esplanade strips that were taken over 4 hectares in the area. And it also had a consequence in that water bodies that weren't on the list weren't required to provide Esplanade strips and reserves. However, I would note that there are some matters of control and discretion and objectives and policies that in general recognise that waterways have value and that this should be considered in subdivision applications. The proposed district plan identifies significant or scheduled, depending on how you take what came out of hearing 5, water bodies in the same way. I listened with interest to the conversation before about the meaning of the notes, because the way I read the rules as written was that on significant water bodies, you would be taking Esplanade reserves or strips regardless of the size of the lots. On the other water bodies, it would only be where there were 4 hectares. But I take Commissioner McMahon's point that the notes are not particularly helpful. So that's the basic, that's the reading that I've used in my submission.
That may have been complicated by the fact that for the first note, the reference was possibly wrong.
Yes, and I think it should actually say SUB S9 1 2. So I think you're missing the 1. And then that says, which to me seems slightly redundant, that the second part of that rule says if you're not on a significant water body, we'll only take them where you're under 4 hectares. That's the basis on which I've read these rules, and my submissions reflects that. So, like I said, the proposed district plan has this, I'll continue to call them significant for these, the significant water bodies where you're looking to take Esplanade strips or reserves on everything. You've got the other water bodies where you're only taking them on less than 4 hectare lots. I have concerns about that because, to my mind, that actually recreates the issue that we had prior to the operative district plan with intermittent esplanade strips and reserves, where you can't get to them, you can't actually literally manage them. These are predominantly in the rural zone. The rural zone is designed to maintain larger lot sizes, and so the likelihood that you would get linked up areas is actually pretty small. I know that a number of submitters have suggested that esplanade strips and reserves should be taken regardless of size, regardless of the water body, but there are costs associated with that. There's compensation costs on the council in terms of having to provide compensation. There's also the matters that were raised by Federated Farmers in terms of creating an environment where you get the landowners on board and the operational requirements and those sorts of things. And so what I'm suggesting is that an approach similar to what was in the operative district plan is adopted, whereby you do identify the water bodies where access is the most important. Where you want to get access down, you target those water bodies, you have the money to actually compensate where you've got larger lot sizes. You've also, if you target things, have the ability to tailor esplanade strip agreements and actually provide them with a bit of backup. I've put conditions on consents throughout the region where we've required esplanade strips. It's a standard agreement. I don't know that they've ever actually had the effort put in to back them up and actually manage them in conjunction with them. So what I'm suggesting is that if you target the approach, it reduces the financial implications, but also enables you to target how you manage them once they're created. So I think that I would like to see the water bodies that are in the significant schedule, Schedule 8, reassessed in terms of that. Careful consideration be given to how esplanades are used and for what purpose, and also what other kinds of mechanisms you can use to actually recognise the other values of the water bodies that were raised by other submitters in hearing 5. So that's pretty much my submission. Thank you.
Thank you, Ms. Johnson. Questions from Commissioner Littlejohn?
Yes, thank you, Ms. Johnson. As usual, very helpful and very practical evidence, and I can't say enough how appreciative I am of someone who's had their head in this for so long that they can come out with such useful propositions. I wanted to talk to you about two things. One is more for you to clarify to me what you are saying in paragraph 52 of your evidence. And I appreciate that we've got a couple of balls in the air at the same time here with the eco rule, but I must say I struggled to get to the end of paragraph 52 and understand what it is that we were supposed to do and in what circumstance. So could I ask you just to help me with that?
Certainly. So when I made the submission produced the evidence with regard to the eco chapter, at that time all we had was the SNA rule Eco R6, which basically said you could create an additional allotment, but it still cross-referenced you back to the effects standards in the subdivision chapter, including the minimum lot size. At that time, that minimum lot size still said you had to have a 20 hectare balance. Ms. Lawrenson has subsequently included in S1 something specific to Eco S6, which means that I no longer have to say, don't look at that S1 scenario because it just confuses things. Ms. Lawrenson's clarified that you can have a 4,000 square metre section as an additional allotment over and above what was included under R4.
Okay, and that's because the 20 hectare balance allotment requirement has been moved up into the rule itself. Is that what I understand? Yes. So that's come up now front and center into the rule. I mean, it was always there, but the duplication's been removed. Okay. So if we're looking at solely doing an Eco 6 subdivision, we only have to worry about a balanced allotment of 4 hectares. Is that your understanding? You probably don't have it in front of you. I've got the benefit of having.
Oh, sorry, I don't.
Okay, no. So that's how I understand it. Okay.
I think it's what Ms. Lawrence has included has clarified what
Yeah. Okay.
that role, whereas before we still had that mismatch.
Okay. Latest plus amended 4. Okay. And then so thank you for that. Esplanade reserves and strips. Yeah, I mean, I did find your evidence very helpful, and from your overriding sort of experience in the district, would you say that the strategy around securing these significant access opportunities adjacent to water bodies has been consistent?
In terms of my experience, it's predominantly been from my engagement in conjunction with a survey firm. I haven't processed a lot of consents on behalf of the council where that was arisen, but what I can say is that generally strips will be taken. They may not be taken at 20 metres, but they will be taken. So New Holmes District Council engages a landscape architect, which goes, because the rule in the ODP is quite blunt, it's a 20 metre. They go out on site and actually have a look at it and give you a bit more specificity. So you are getting the Esplanade strips.
All right. Is there any way of identifying, except by using the layers on the E-plan, those locations where the PACs, these public access corridors, coincide with preferred locations for future esplanade strips or reserves adjacent to water bodies?
That might be a question for Ms. Lauritsen. My understanding is that access strips are designed to provide access to the esplanades. So rather than the actual esplanades themselves, they provide you with a way of getting there.
Yeah. Yeah, it's not, they're sort of slightly different purposes, aren't they? The access corridors versus the reserves, the esplanades around water bodies. Okay.
I do have a comment to make. I spoke to Ms. Young about this, and I did take some notes, and again, hopefully it's helpful. So the PACs will be on the maps and not in a schedule, was my understanding. But all public access streams are in the schedule for the water bodies at the moment. So if there's does that make sense?
So the schedule of water bodies are all water bodies where, if we went to the map, we would also expect to see a PAC identified around them or adjacent to them?
No, sorry, I think it's the other way around. So not all water bodies are PACs, but the PACs are all in the schedule. If they've got a water body attached, and the water body is in the schedule. But I can confer with Ms. Young.
Yeah, okay. Like I'd appreciate this. I mean, I think there's a real consistency of objective here, and it's about using the right tools and the right locations to reach those objectives. And I'm not just talking about it from the strict let's take land for esplanade, because of course the purposes of these strips are somewhat greater than simply public access. And in some instances, public access is not appropriate at all. So we just need to make sure we're using the right tool for what we're trying to achieve. So I do appreciate your evidence. Thank you, Ms. Johnson.
Thank you.
Yes, there's not much more I can add to that other than just repeat what I said earlier about consistency of terms. The heavy lifting should be done by the water bodies chapter here. So whether we're referring to significant water bodies, natural water bodies, Schedule 8, Schedule 9, I can't get Schedule 8. Like with Indigenous biodiversity and Indigenous vegetation and habitats, the terms should be the ones that are introduced into that ECHO chapter and used in the Esplanade provisions, because I can't see any policy differentiation in the subdivision chapter or any policy rationale relating to the taking of Esplanade reserves. I may have missed it. Can you help me at all, Ms. Johnson?
My understanding is that they sit within the water bodies.
Yeah. So hence the terminology should be one.
Yes, and I was aware at the time that I was writing my evidence that I was referring to water bodies after in hearing 5 making the point that water bodies also include piped.
Yes.
It's a bit tricky to keep it.
And the only reference I can see in the policies is P4, where it talks about managing the impacts of subdivision on, amongst other things, water bodies.
Are you looking at the water bodies?
No, this is the subdivision policies, but there's nothing, I can't see anything else in the subdivision policies about Esplanade strips or Esplanade reserves. We would find those in the WB chapter.
That's my understanding, yes. Which was why I was a little confused about why the standards were on this chapter.
Okay, two other questions while you're here. The connection to a reticulated water supply in the rural zone, what changes are you, I can see the changes that you're proposing in terms of the first issue that you raised on water supply in your appendix. Possible that I've missed it all together, but you made a change on page 22, but that wasn't for the rural zone, was it? That was for other zones.
So that's correct. In the first pass, which is basically urban areas and the requirement to have a reticulated connection.
So sub S5 was one. Yeah.
So I'm not arguing that with the need to have a connection. I just want to clarify what that connection consists of, and whether, if you're at some distance, what the expectation of council is with regard to that connection.
So when you get down to 2 for the rural zone, there's no change required.
Well, it kind of comes back to what the council's response to my request for clarification are. I haven't made any changes because I'm not quite sure what they want. So it still uses the term unavailable, which kind of negates getting rid of the term available in the first part.
I mean, will there be some scenarios in the rural zone where connections to the council's urban reticulated water supply is available?
Not, I couldn't comment on that. The council might be able to help with that.
Because that scenario is not contemplated by subclause 2.
Well, it depends. I mean, as it's written, if there is an urban reticulated water supply, then the way I read it is that you have to connect.
Are you reading that in subclause 2?
Yes.
Where a connection is unavailable, or it must be provided with access to a self-sufficient potable water supply.
So I guess it could almost be seen to be mute on what happens when there is.
Well, clause 9, if there's no requirement to section 9 of the Act. You don't need consent. You don't need consent. You don't. Anyway, but the real matter I wanted to ask you about was, and you haven't covered it, but I just wondered about if you could shine any light on your experience with the land development code manual, whatever we call it, under the operative district plan. you just remind us what the scenario was there under the operative plan? I know you were one of the authors of that plan.
I'll put a caveat in that the reference to the council's adopted land development subdivision infrastructure standards,
Yes.
or CALDIS, was actually done after I left council, so I was not involved in including that in it. I was a submitter on it, noting that it was incorporated by reference to enable.
You're talking about the proposed plan?
I'm talking about the operative plan.
Okay.
So reference to those standards, because I think they came out in 2004, and then they were subsequently amended again in 2010, and the 3 district councils had some input in to make them relevant to their particular districts.
Right.
So prior to that, we just had the requirements and the appendices to the district plan, which it's quite a long time ago, so I don't remember exactly what those are.
So what were they extracts from the standard, or what were they?
I'd have to look at what's in the operative district plan. In memory, we had the requirement to include, to connect both to sewer and water within 200 metres, but there was no reference to any specific standards. I think that came out through the conditions that you imposed on the consent.
Was it an impediment for the consenting staff working under the operative district plan not to have a mandatory requirement to comply with the standard?
That's not a question I can answer.
Okay. Okay, I'll leave it there. Take it up with KO tomorrow.
Thank you, Ms. Johnson. I have no questions.
Thank you.
Thank you very much. The Waka Kotahi, only an hour and a half behind schedule, but we're still here. And hopefully you are there too, Kath. There's less people to wait on the Zoom. So let's give it up on us.
Can I just check, so sorry, I'm late to this one, but is there a Paul Sousa?
He's already been through it. Yes. In the meantime, we'll get going with PRIP. Thank you. We have some missions members already.
Yes, I have 10 copies here.
Fine.
That's just hand back to you.
Yeah. Those being pre-circulated by Julie, Kat, so you should have those level submissions.
And Mr. Edwards has also prepared a summary statement as well.
Thank you.
Right, so would you like me to, have you pre-read these submissions, Commissioners? Would you like me to read them or hit the main points?
Have you read them?
I completely missed this.
Yes.
Yeah.
That's fine.
Well, I would take us through it fully as you like, I think. Yes.
So at the hearing, I should say that I do recap a lot because there's background from the previous hearing. At the hearing on the 23rd of August, David Scott, the Chief Executive of New Plymouth Airport, provided evidence on the nature of New Plymouth Airport, the only commercial freight and passenger airport for the Taranaki region, the growth that the airport has experienced, albeit reduced in 2020 and 2021, the existing 1310, that should say metre length of the main runway is constraining aircraft operations currently for ATRs in certain weather conditions and for the future. The need to realign the runway to provide additional length, but the significant constraints around runway redevelopment, including cultural at both ends of the current runway, topography and coastal erosion issues. The PRIP submission seeks to reduce potential constraints to runway realignment caused by reverse sensitivity effects. Evidence at hearing 4 laid out the disconnect between notification of the proposed plan and more recent aircraft forecasting. Whereas the 2014 master plan for the airport was used in pre-notification consultation on the proposed plan, much more recent airport planning has occurred, and this includes investigating options for a longer runway under a multi-criteria analysis or MCA. And further work is occurring with further master planning to commence imminently, but it's been delayed. This means that the existing noise contours around the airport, shown in the proposed district plan, it should say are out of date, not end out, are out of date, and they will not future-proof the airport. PRIP intend to initiate a plan change to redress this situation. Before any plan change can be initiated to update airport noise contours in the proposed plan, it's important that residential development decisions don't effectively preclude the upgrading of the airport through allowing significant reverse sensitivity effects. Hearing 4 dealt with consenting requirements for noise sensitive activities within the following airport contour lines. I should actually say that the first 2 of these contour lines were actually developed in 1998, but rolled over. And C, is, the 50 dB contour was developed in 2013, 2014. So the first one, and these are established contour lines based on the New Zealand standard. The first one is known as the air noise control boundary, the 65 dB. Second one, the outer control boundary, the 55 dB, and they were rolled over from the operative plan. And then the third contour, the 50 dB, is not currently on the planning maps, apart from in relation to the Area Q structure plan map. And that was developed on the basis of 2013/14 master planning. At hearing 4, PRIP explained that the 65 and 55 dB contour lines in the proposed plan need to be updated. Due to more recent planning, these are no longer fit for purpose. However, the submission does not provide scope for updating these lines at this time. So PRIP submission sought that the 50 dB contour be utilised to future-proof the airport, pending future work that the airport has to do to revise the 65 and 55 dB contours. That is, the 50 dB contour developed in the 2014 master planning be used as a proxy or surrogate for illustrating the likely augmented future noise profile of the airport, pending a future plan change. And at that hearing, the usefulness of the 50 dB contour was illustrated in figure 4. And can I take you?
Well, the problem is that I wasn't part of hearing 4.
No.
So,
But I think that's why I've asked Zombie to be fulsome of your
yeah,
background, so if you want to explain that further with reference to the plan, Zombie.
Yes, if we could turn to figure 4, which is attached. This is probably quite complex, but I have to say also that it's coming up in another hearing, which is the Area Q hearing, which is the development rules, because this argument was accepted for Area Q. So if you look at the blue line, Commissioner, that shows the 50 dB contour developed in the 2014 master planning. So this is the line that the airport is now seeking be imposed on the planning maps as an indicative noise contour. And Mr. Edwards' evidence at the previous hearing covered this. It's effectively an airport noise notification area. So that blue line would encompass the realignment options, which are shown in the dotted lines. So the usefulness of it is effectively that it puts people on notice that the existing contours in the plan, which are much narrower, are not the end of the story. There's likely to be future development of the airport, which will increase its noise profile. But the difficulty we're in is that not enough work has been done to define those future lines.
But presumably the future line will be a lower profile.
A future 55 and 65 dB line would be a lesser profile than the blue line, but would probably be within the blue line somewhere.
Yes.
Yeah.
And so what, so it's an interim method.
Mm.
How long would it survive for until the plan change was, for what sort of period are we talking about?
Well, Mr. Edwards can probably answer that better than I can. Do you want him to just jump in?
Yeah, I mean, it's an interesting question. I mean, we are sort of talking about the kind of need for it now, imminently. But that's the airport's decision. It is, looking to advance that master planning. So I know it's working on that now. And once that's sort of confirmed as a sort of preferred option, then the plan change work can roll out afterwards, I think. But in reality, I think it's going to be at least sort of 12 months away. At least. So as a thumbs up.
Just sorry, I'm trying to just remind me, what's the effect of that indicative? What does Mr. Lloyd call it? What do you call it? It's an indicative, the blue line. What's the effect of that on the ground for resource users other than the airport? So in my hearing for evidence, where I landed was that it should, for the noise chapter, so for residential development and additions and alterations, it should be just like an indicative contour, not with any regulatory blight. So just an awareness sort of piece. Does it require noise insulation or internal ventilation?
Not to the 50.
Not to the 50.
Not to the 50, but that applies to the 55.
Yes.
Yeah.
Which have been rolled over.
Yeah, and we did test that with Mr. Peagle, the noise expert, and when we looked into it further, I mean, his view was, and it wasn't in all cases, but most likely in most cases, that if you applied a sort of insulation standard to it, those dwellings would meet that standard, the vast majority of the time. But it was quite clear that there would be scenarios where it wouldn't be met. But yeah, from an efficiency point of view, where I landed was I couldn't really say that that's appropriate for the whole 50 dB.
Yes.
Yeah.
But the out of control noise boundary and the air noise control boundary both have regulation associated with them.
Yes. Yeah. So between the out of control boundary and the air noise boundary, it would be a requirement to meet the insulation standard. And within the air noise boundary, it's a non-compliant activity.
Okay. Thank you.
David, we did request to implement this conferencing at the noise hearing for,
Right.
and there's only sort of goes on and explains where they ended up. So
Thank you.
hopefully,
I think I'm catching up.
yeah.
Yeah, thank you. So.
Thank you for that.
I'll try not to go.
That's okay, I can say that
detail.
I do have some experience in this because I've been involved in the Wellington International Airport designations of late, where they've sought to extend their footprint, if you like. But interestingly enough, there's no out of control operating at this Wellington Airport.
Is it 55 dB or
Yeah,
555 dB? Right.
Yeah.
All right. Well, so just also an answer to your question, Commissioner, without wanting to jump too far ahead, I think Mr. Edwards has said that in the noise chapter, there wouldn't be proposed to be any regulatory control associated with the 50 dB blue line. I should say that it's hoped that it would be included on LIMS, which is separate to this process. And without wanting to jump too far ahead, we're seeking a reverse sensitivity policy in this process, in this hearing today, that would reference that 50 dB line. Okay.
it's good background, thank you.
Yeah. So I think I've covered paragraph 9. Paragraph 10, I provide background on the bell block area Q chapter, where this was effectively accepted that the 50 dB contour be shown over area Q and associated with controls. And because that's a part of the future hearing, I don't propose to go through that if you don't mind.
That's right, but the key point in 10 is that the last sentence, isn't it? So
Yes. Yes.
cover that as well in the last hearing.
Yes, so the airport sought that the 50 dB contour line be shown in its entirety in the planning maps. Currently, it's only shown over area Q.
Yeah.
Yeah. So last sentence of paragraph 11, I'll just go there. If reverse sensitivity effects are not addressed before a plan change is promulgated, on a worst case scenario, such effects could force a complete relocation of New Plymouth Airport. So with the expert conferencing, I can effectively just summarise that, Commissioners, by saying that everybody just essentially retained their original positions on this matter.
Have you looked at those statements, Kit, since hearing 4? Your speakers off.
No, I haven't had a chance to look at those.
But they are online. Charles, do you know if they're online, those hearing 4? No. What the statement?
Videos will be online.
No, we had some joint witness statements after hearing 4.
I'll check for you.
I'm not even certain.
I don't think they are.
No, I'm not even certain we've been alerted to them. Kit, does that ring a bell? So I did have a question of Mr. Edwards. Sorry.
Yeah, I'm not. So I'm just on the hearing page for 4, and yeah, Julie is pretty good at sending anything that comes in that we ought to look at, and I haven't seen anything there, and I can't see anything on the hearing 4 page. So maybe they've just ended up in someone's inbox and haven't been produced further.
Well, apologies for that. I think Mr. Edwards, you've sent them to the hearings administrator, but haven't you?
Yeah, that was sent through by Mr. Wesley, actually, but they have been issued some time ago.
Yes, I saw the date, I saw the reference in your evidence, Mr. Edwards, so I was going to ask your question about those. So anyway,
I've got a copy here.
Sarah, you're summarising them here, and you're saying nothing was advanced.
Unfortunately not. Just to diverge from that, you'll recall that there was also a request to put the nighttime noise boundary, I haven't dealt with this here, but the nighttime noise boundary in, and that wasn't agreed either. But I've suggested to Mr. Edwards that to wrap everything up, which I haven't done here, that at the next hearing, the airport wrap everything up with a track change version of everything that the airport's requesting.
Is that a special purpose zone hearing for the.
I think that's what it's called.
Yeah.
And that's, I think, coming up next year.
Yeah.
Actually, Stephen, I've found it. It is an attachment to, it's an attachment to the staff right of reply,
Oh, okay.
written right of reply for the 42A report on hearing 4. So right down the last document is
Yes.
written noise appendix 6 joint witness statements relating to the New Plymouth Airport. So we did get it, but it was buried right at the bottom of the last document.
Okay,
Okay.
we have it.
Yes. The probably the most useful part of these submissions in terms of this 50 dB line would be where I summarise its footnotes 8 and 9, if I want to refer to those. Provides the reasons why Mr. Lloyd retained his position and Mr. People retained his position. So I can let you read those now.
All right, so this, just really reconfirms the differences of expert opinion that were apparent
Yes,
in the hearing 4.
yes.
I guess planners really didn't have a position to disagree with, given they were relying on expert noise expertise.
Well, they still found themselves able to disagree, so.
Yes.
I've often said that about planners.
Yeah.
They weren't able to agree because the experts
Yeah.
were diametrically
Yeah.
opposed. So
Well, they can't create the evidence, can they?
that's right.
Okay, so we're moving on.
So moving on to subdivision paragraph 17. PRIP seeks non-complying activity status for subdivision on the rural production land between Area Q and the airport. In his planning evidence, Mr. Edwards supports this relief and proposes a new subdivision rule that would provide for it. Paragraph 18, figure 4 shows that upon a preferred runway alignment and produced on the basis of option 5 in the MCA, a future 60 dB contour could traverse a large part of the area between Area Q and the airport. So this is obviously supporting the non-complying activity rule if you look at the realignment option on the plan.
Yes.
That is, in a future realignment scenario, these rural properties could well be subject to increased levels of airport noise. The Section 42A report analyses the submission and states, subdivision on all but one property between Area Q and the airport would be a non-complying activity anyway, for other reasons. This is relevant to your Section 32AA assessment, and I submit the relief sought is justified by the Section 32AA, and Mr. Edwards goes into that further. So do you have any questions, or would you like to wait for Mr. Edwards' evidence on that?
Yeah, I think we'll wait. Yeah.
Policies. PRIP made a submission seeking sub P13, now sub P14, be amended to include the words including special purpose zones. This is set out in paragraph 21. The officer does not consider the change to be necessary. So the change requested is set out in paragraph 21, which is clause 4, which is regarding reverse sensitivity, and it's to insert the words noise contour boundaries in there. So Mr. Edwards will discuss this further. Should the relief requested at hearing 4 be accepted, this reference to noise contour boundaries in clause 4 would include the indicative noise contour 50 dB boundaries. So it would be brought in for consideration at least in subdivisions there. For the land between Area Q and the airport, should the relief above be accepted, subdivision would be non-compliant. The additional policy change would have implications for the land within the 50 dB contour, but not between Area Q and the airport. And for this land to the west, south and east, and I'm talking within the blue line or around the blue line, various assessment criteria matters of control already refer to reverse sensitivity, but this is only in general terms. And Mr. Edward considers more specific references required. More specific reference to noise contour boundaries in the policy will ensure that in any consenting process, adequate analysis is undertaken against the airport noise contour boundaries as well as against general zone boundaries. And for any subdivision consenting process, the appropriate reverse sensitivity analysis focused on potential airport noise would occur on a case-by-case basis, and the runway realignment projections would be specifically considered at the time of subdivision. So scope, I've provided previous submissions on scope, and I don't propose to read the rest because it's effectively summing up, except to say that regarding the non-complying activity request that for the area between Area Q and the airport, as in paragraph 26, Mr. Edwards provides an alternative, which is to draw upon a development rule that would provide a pathway to subdivision relying on a reverse sensitivity covenant or other agreement that binds successors in title, instead of having it straight non-compliant, because this is what the Area Q rules provide for. So those are my submissions, which set out the background, and now Mr. Edwards.
Thank you. Do any of the commissioners have any other questions for Ms. Olney?
Yeah, just Sarah, if I could just cut to the chase and say or ask, because the airport did make a very clear submission that all land between Area Q and the airport have subdivision as non-complying. Would that be enough as an interim holding measure from a reverse sensitivity point of view, or do you think that would be a cheap alternative, and that to make it actually work, you do need to invest a little bit of wording into the policies in the subdivision chapter to make it have teeth?
Yeah, I think that the policy request that the airport's seeking, which was in a further submission, would support that non-complying activity status as well. It would support the non-complying activity, but Mr. Edwards and I have been constrained somewhat by the original submission, which neither of us were involved in preparing. So we're sort of trying to do the best we can. So there's the issue about whether simply just making it non-complying is enough without a supporting policy framework. But there's an issue about, well, there's the area between Area Q and the airport, but a possible realignment scenario could have implications beyond that, and so that within the rest of that blue line. So
Okay, no, that's all I wanted to ask. Thank you for the submissions.
It is a problematic, but Mr. Edwards and I have tried to provide the best possible relief in the circumstances.
And, you know, it was very clear to us that you were trying to make a silk purse out of a sow's ear, if that's the right analogy, or...
Well, I don't want to give a drink, but no, there has been a lot of things going on with the airport, including the terminal upgrade and various other things that have been focused upon. So
Now, that might be an efficient term, but one question I do have is that you've signalled that the master planning is happening and is underway and has been underway through this last year, but there's still time to go, and that a plan change will be needed. the council supportive of that plan change?
Yeah, I don't know, Mr. Chair, if the council is supported, it's obviously a council entity, although it's separate, it's its own sort of operating entity, but it is a council organisation. In terms of that level of support, I don't know. I don't know. Yeah, I don't know what discussions the airport has had with council in that regard.
I think I made some observations at the previous hearing that given the obvious key infrastructure that the airport is for the district and the whole region, from a planning point of view, there seemed to be certainly some urgency about this. And I'm not sure what that's why I was interested in the planners witness statement where everyone just disagreed. Whether there was any context, extra context about, well, okay, we've got an issue here, we need to get on and deal with it.
No, I mean, there just wasn't any discussion along those lines in that broader sense. It was just on the matters at hand, I guess, that were said on the in the questions, I guess. I do know as part of the MCA sort of exercise, that I should say, caveat that by saying I wasn't directly involved with it. There were council representatives in that process, and that's not to say the council agrees with that process, but I think that process popped out a number of clear outcomes. In that, if it was to be extended or realigned, then the preferred option was the realignment, more parallel with the coast. But I couldn't say the council supported. I simply don't know. Yeah.
But we've had some submissions today from Mazzoni that the worst case scenario is that the airport becomes not effective or not operational or future proofed. And certainly by the time of the special purpose zone airport hearings, if I'm just looking at my guidelines here, occur in middle of March next year. I have to signal both the airport and also through unit of the council team that it seems to me we need a plan. Does there need to be a variation? Does the airport company has its own rights to designate, and whether those sorts of processes might be available? Or another thing at the back of my mind, when plan change has been promoted, that's got to be supported by the council. A private plan change is available. I'm not sure you can do those while plans are still in flux. Whether you have any comments on those, that line of questioning. And whether you have anything to add?
Well, it's really going to be up to the airport to give the issue I guess the wind in its sails. Really, there's no prospect of a plan change at this point. It would have to be a variation, which means the council would have to be persuaded to promote a variation. So, yeah, it's I think Mazzoni summed it up. The airport's in a rather uncomfortable position right now in this particular aspect of it. Yeah.
No, thank you for that though, Commissioners. That does, providing that signal does actually is helpful with Mr. Edwards and my discussions in terms of the urgency of this. And when I said plan change, it was assuming that it would have to occur after the current plan became operative, but of course we don't know when that will be. Yes.
I mean, if I can add to that, one of my other roles is assisting Nelson City Council with the rollover of designations for Nelson Airport, and they have 3 designations: a ground designation, a near noise boundary designation, and a near height designation. They're all in the operative plan. They're looking at runway extensions at the moment, and they're looking at, they've rolled over their existing designations as an interim measure, but they are looking at to issue a new notice of requirement for all 3 designations. And that notice of requirement, once issued, will have an interim effect under section 176.
Yeah.
So in terms of the bundle of tools at your disposal, that may be your best mechanism. You're going to have to do the work anyway,
Well,
whether
I
it's
was
a
just going to
variation,
say,
a plan
yeah.
change, or whatever, and it's going to rely on technical expertise. So I guess the only thing I can say is that with the designation, you're driving it yourself as the requiring authority.
Commissioner Littlejohn's right, it's the ball has to be in the airport company's court. I've given these comments on the basis that this is an important planning issue. The district plan is deal with sooner rather than later, in my view. We're constrained to what's in front of us, so that's goes without saying.
And in that sense, what we're looking at is a band-aid type approach that involves a reverse sensitivity policy and either a non-complying or a DA rule, depending on which of Mr. Edwards' alternates are supported.
And an indicative line.
Yes, and an indicative line. But they all are, they're not enduring, are they?
No, it's a transitional.
Yes.
Yeah.
All right, well, look, I think it would be important to have that discussion pretty openly. And we'll just hear from whether anyone else has any questions for Liz Onwin. Okay, Edwards, we'll just move to you, thank you.
Yeah, now, Commissioners, I'm not sure if you received my kind of executive summary of the pre-circulated evidence or not. It's just a 2-page.
Charles, or not?
I do have a few spare copies.
Okay, well, that would be helpful, thank you.
There's nothing new in there, so. No, sorry. I think before just going into this, kind of in that discussion about, who's, it's the airport company council. So, just to acknowledge that Hoki Tapu are going to be instrumental in that as well, the local Hapu, and so that's an important part of the equation as well. Okay, look, I'll quickly whiz through this executive summary. I'll skip to paragraph 3, and look, we've touched a lot of that background and that contextual, or the context for the evidence and the subdivision issues at hand. And Sarah's pretty much covered all of those points. I guess the one thing I would touch on is in point 3D there. One thing I've been conscious of in drafting my evidence is that inherent tension of residential growth and land supply in the NPSUD and the operational airport, sort of acknowledging that demand for land, for housing and growth, and there is that tension there. But as from what I can see in terms of the section 42A reporting, it has the council has identified its short, medium and long-term land, and so it doesn't appear to be a need for more in that regard. So it is proposed to be zoned primary production, and as an activities-based plan, I would expect it to have a rural use in that regard. I'll just quickly go on to the section 42A report. Ms. Lawrenson really helpfully sets out some really good analysis of the potential to subdivide the parcels between Area Q and the airport. So the airport submission did seek a non-compliant activity status, and I think out of the legal parcels between Area Q and the airport, I think Ms. Lawrenson's analysis identified that they all bar one would be in a non-compliant activity in any case. There is one that squeezes in as a discretionary activity, and that's the parcel closest to the terminal that's not owned by the airport company.
The parcel 7 on the.
Correct.
Yep.
Yes. Yeah. So that could be subdivided as a discretionary activity. I guess where I landed with that is, and linking back to the nature of the airport, it is an asset of regional importance, and I guess while in the main it might be non-compliant activity in terms of those subdivisions, my view is that the plan needs to have a direct response, I guess, in terms of an asset with such importance to the economic and social well-being of the district. So I think the way it works at the moment in terms of those subdivision provisions, it is a consequential outcome as opposed to being addressed very directly, and I think it
You mean it's a default outcome?
yes, the
Yes.
default outcome.
Yes.
Yeah. Just by the lot size and the parent title analysis that Nicola has done, it's a default outcome, and my view is that because of its importance, we should have a very firm steer of what's acceptable or not. So, and then why do I think that? Obviously the importance of it, it gets that back in, I guess, in terms of the higher order documents, in terms of the RPS and infrastructure policies 1 and 2 for the RPS, and obviously it is embedded in the strategic directions as well in terms of UFD 21 of the proposed plan. So it's recognised as being important, and therefore should be an issue that is addressed. I'll quickly nip down to the relief I'm seeking. So consistent with the airport submission, I am recommending a non-compliant framework for subdivisions within that 50 dBA contour profile, but it is explicit to that area between Area Q and Te Hono or the airport. I think the scope of the airport submission is such that it can be broader than that. So it would be a defined set of legal parcels as Ms. Lawrenson has identified in her 42 report. And then I think it does need that policy backing in terms of it's all well and good having a rule, but you need that sort of backing from the policy. And so the recommendation there is to include a reference to noise control boundaries, which are obviously broader than just a zone boundary, which with noise in particular, obviously it crosses that boundary. So I've made a recommendation to amend. I think it's subdivision policy 14 is recommended in the officer report. I think I've referenced it incorrectly as Susan.
So where's the incorrect reference?
Sorry, so that's in the executive summary on page 3, paragraph 9, but it's without looking at my main evidence in sheet there, it's probably through there as well, to be honest.
Right,
So they should be 14 instead of 13.
Correct, yeah. Yes, yeah, I think there was an additional policy recommended that we put in there. But simply as where it says 13, it should be 14. And then as Sarah's alluded to, it is, if that option or recommendation isn't favoured, there is an alternative option I've looked at in terms of this controlled activity status for a subdivision that imposes a sort of what is in effect a no complaints covenant on the title. And that is consistent with the outcomes of Plan Change 20 to the operative plan, and that is what is proposed in the Area Q development area as well. So I think that's Rule 7 from memory, but it is consistent with that Area Q framework. You know, if that thing is here, so it is 7, yeah. So that's on page 7 of my evidence achieved there in the main table. So that's a snippet from the area Q provisions.
Yes, I was having to.
You need your glasses.
I actually don't need the glasses. I'm going to go further back. I'm on the opposite of needing the glasses.
So that's an alternative way of trying to, you know, manage that really sensitivity issue if a non-compliant activity status is not favoured. The other would be a discretionary activity. Obviously, that is a different process to a non-compliant activity, and not the gateway test. But I think, you know, on balance, it probably gives enough with that addition of that the noise control boundary reference in the policy to provide a bit of a package to manage those effects.
Before we go to Mr. Commissioner Littlejohn, before it slips my mind, you've mentioned that the policy and the rule relies on that 50 dBA contour coming into the plan.
Yes.
It's not there currently except for the area Q.
Correct. Yeah.
But you have asked, the airport has asked for it to come into the plan, is that right?
Yes, correct. Yeah.
But that wasn't agreed to come in as part of the planner's witness.
There was disagreement in terms of whether that 50 dB contour should be in or out.
Okay, so your relief you're seeking here relies on that to happen first.
Yeah.
Which isn't agreed between the planners or the noise experts. And is that why you're suggesting this additional idea as an alternative, or would you prefer alternative 1, the non-complying status and the conclusion of the noise boundary?
Yeah, I mean, maybe just to comment on the policy. So I don't think the policy change is dependent on the 50 dB.
Okay.
To make that point.
Yes.
So that would apply, you know, in a broader sense. Not, you know, and also any of those, I guess you could say any of those parcels affected by potential subdivision that could be inferred, be it, you know, impacted, so whether that be discretionary, non-compliant, whatever. So it could be assessed in a policy framework.
Could I just explore that a bit further? So looking at your page 9 of your evidence, top of the page it says and amend sub P13, that should read sub P14, is that right?
Yeah.
And your suggestion insertion is the insertion of noise contour boundaries. So it does, if the 50 dBA isn't in the plan, this wouldn't work, would it?
Not for the 50, but it would for the 55 and the
Which are in the plan.
Yes.
Right, but not for the border area that you're trying to use as a proxy.
Correct. Yes.
They're not very far ahead, are you?
Not substantially.
Without that, but even that 50 should come in.
Except that, yeah.
Right. Is there anything else you'd like to tell us, or should we just go to questions?
No, yeah, happy to go to questions. Yeah.
Yeah. Kit, do you want to kick us off again, please?
Yeah, look, just there's not really much I need to ask. I think the suggestions are clear and logical in terms of what the airport is trying to achieve with the tools that it's got available to it. I am interested in the assessment in the 42A report around those parcels of land that are in the, I guess, the sensitive area. And I think it's fair to say that even though they might be non-complying, that they're not non-complying by dint of the fact that they're trying to locate a sensitive activity next to the airport. They're non-complying as a breach of title rules or lot size. So the policy framework is really not set up to provide a real barrier, if that indeed was the only other thing that was an issue there. Just on the policy framework, have you had a look at the airport zone policies in preparing for this hearing? Because there is because I understand that all of the objectives and policies that are relevant in any particular case would be brought to bear if the application was non-complying, and indeed if it was discretionary. So it's not just the ones in the subdivision chapter. So the airport could presumably pray in aid of any position in opposition to a subdivision, the policies and objectives in the airport zone, and I suspect all the way up to the strategic objectives, which do make a specific reference to the airport as being significant infrastructure that needs to be able to operate. So have you thought about it in that sort of a constructive, broader policy framework that supports protection of the airport?
I have at a high level, and I guess that's why there is no, what I would call, say, hammer in the subdivision provisions or the policy framework, rather a subtle reference to it. Because I agree that if it is a discretionary or non-compliant activity, then all those provisions that may apply would get considered or assessed as part of that decision-making process. So the real grunt, I guess, or the real substance in terms of that protection would come from the airport zone provisions. I haven't gone through them in detail in preparation for this hearing, to be honest, but my recollection of them was that they, to a large degree, it was about effective operation and maintenance.
I'll let you know. I've been reading ahead, and Airport Policy 6 says that ensure that any new sensitive activities seeking to establish adjacent to the airport zone are designed and located appropriately to avoid reverse sensitivity effects and or potential conflict with permitted, consented or lawful established activities occurring within the airport zone. And where avoidance is not possible, they shall be remedied or mitigated. So that's a fairly big policy tool that, assuming the airport got involved on any subdivision adjacent to it, it could potentially rely on. Do you agree?
I'm not necessarily convinced with the term or the word adjacent, and what does that mean? Okay. Look,
We've got a submission.
Oh yeah. Okay. But there is a submission point on that very issue, with the airport seeking a broader reference to surrounding environment, which I'd be a lot more comfortable with. But I accept the point. Yeah.
Okay.
Yeah.
All right. No, well, thank you for thinking about this problem and suggesting to us, I guess, relatively efficient ways to try and address the matter in the short term. So I appreciate the thinking you put into it.
Thank you. I don't want to overcomplicate this because I'm new to it. Do I ascertain that there's some limitations in terms of scope based on the submissions or further submissions that you weren't involved in preparing? So,
sorry, I should correct that. We did have input into further submission,
yes,
but not the primary submission, which obviously sets the scope.
Yes, it does. I mean, you can only support or oppose at the further submission stage. Yes. So, what's clearly in scope is alternate one rule within scope?
The non-compliant activity. Yes.
But the policy is a little bit uncertain. There's no specific relief seeking the policy. Is that what I'm hearing?
Yeah, if you could,
So there's a further submission. It's least certain. I'd say it's least certain, but I in terms of the fair and reasonable test, yes, the reading the original submission of the airport as a whole, I think also supports that, because it says things like the airport is concerned to ensure that the proposed plan enables safe and efficient operation of the airport and the use and development of land around the airport is controlled such that reverse sensitivity effects are avoided.
I
So,
understand that, but what's,
yeah.
who's the submitter and what's the relief source?
Okay, so the submitter was Horticulture New Zealand.
Yes.
And I think they simply supported the policy. And
Which
then,
policy?
13 as it was.
13 as it was.
and then the airport came back and said that, yeah, but the zone boundaries should be changed.
Yes, but you can't seek relief at further submission stage, can you?
Possibly not.
Oh, look, I'm not trying to be difficult, just trying to
No,
understand
but
what's.
Commissioner, in terms of a fair and reasonable test, and the extent of that in terms of a policy change, I mean, it's not a rule change, it's not a trigger or anything for a rule. It's putting the policy that the airport sought in its submission, in its original submission, into words in a policy context, but the exact words weren't actually sought in the original submission.
No. Is it, accept that,
Mm.
is it too high a bar to say that the additions to P13 that are in Mr. Edwards' evidence are a consequential change to the non-complying activity rule that is within scope?
Well, no, I don't think that's too far to say that.
Would it assist if the panel knew that there were other policies and other objectives going up the hierarchy within the plan that supported the additions to P13? So, I mean, if you could identify those,
I'm not quite sure what you mean.
well, we know, for example, that the strategic objectives include a policy relating to the regional significance of the airport. So that's an umbrella policy. We know that there's policies in the airport zone. Are there any other policies that would provide a flavour that would assist in giving the panel some comfort in adopting those additional 3 words to P13?
Oh, I see. Yes, well, I mean, Mr. Littlejohn's touched on the airport zone policy, so would you like us to come back on that?
Well, the answer may be yes, I would. The answer may be no, there aren't any, but there might be something that someone's missed.
But there's the regional policy statement. When you referred to Mr. Edwards and
Infrastructure policy 1 and 2.
Yes.
Yeah.
I'm thinking more within the plan itself.
I mean, the strategic direction, UFD 21 is the one, I guess, you get
Yes.
immediately drawn to.
Yes.
Yeah. But
I'm just looking for a line that
Yeah,
shows that
yeah.
this rule, so this rule has a policy basis in the plan.
This policy has a policy.
So this rule
Oh, the rule, okay,
has a policy basis.
right, I see, sorry.
So, David, what do you think about that TRP in policy 2 in paragraph 15 of Mr. Edwards' evidence he's identified from the Taranaki Regional Policy Statement? Isn't that on point?
It is, as giving effect to a high order document. Yeah, absolutely. I'm trying to see what the policy equivalent of that in the proposed plan is to provide the basis for the method in non-complying activity number, whatever it's called, R42.
I think.
Sorry, that's a bit clumsy.
No, I think what we need to do is just have a quick stock take of, in particular, all of those strategic directions to see if there's anything, along those lines that you're saying, but certainly 21 is a clear.
And it may be as simple as that, you start at 21 and you end up at rule sub R42. It's a bit of a gulf.
Yeah.
But I think the panel would have a lot more comfort if they could hang their hat on something in between, and maybe it's something in the airport zone.
So you'll prepare something and
We can come back to you on that.
thank you.
I guess the only other thing is the point that the chairman raised, and that is the blue line in the plan, and well, how effective are these policies and rules without that blue line in the plan. I guess the rule was more effective because it specifically refers to an area. The policy could only apply to the 55 and 65.
That's a long one. Yeah. But that, yeah, that is one of the major issues with it. Yeah.
Look at 5:30 in the afternoon. We had a good discussion about this, and you've made your position very clear from both the legal and planning perspective. So thank you very much. And we'll do something through just about that policy linkage.
Yes, what time? Right,
What time do you need?
of the week. Oh, do you?
Yeah.
That would be great, because it needs to feed into
Oh,
right of reply.
oh, yes, of
Written
course.
right of reply.
Friday.
2 weeks from tomorrow, so.
Oh, yes.
Yeah, so if it can be done by Friday, that would be great.
Yeah.
Because it's got some homework itself, so.
Thank you.
Thank you.
Thanks very much.
Charles, did we mean to catch up with what the Kotahi?
She had to leave at 4:30, and she will be available tomorrow.
All right, well, I think we just need to pop her in with us meeting.
Be available from 10 to 12 tomorrow.
All right, so are you doing the hearing tomorrow? or
I
did you-
do do that as well.
Okay, so you'll pass it on to the programming. So I think we are finished for today. Apart from over here to finish our day, looking down the end of the room. Yes, thank you, Maria.
Kia ora tātou. Unuhia, ki kura tapu nui o tānei, kia wātea, kia mama, te ngākau, te tinana, te wairua, i te aratanga tū, koia rā, e rongo, wakari ake ki runga, kia wātea, mai rā, kua wātea, pau, mari.
Well, have a pleasant evening, everyone, and we'll see some of you tomorrow. Thank you, Kat.